Partition of property or division of property, what it means. Partition or division of property means the distribution of property among the equal shareholders that have right of claim over the ancestral property, joint property or paternal property. With the inheritance of several heirs, it must be divided among the shareholders, and it should be done or must be done on an equitable manner. The distribution of property can be done by means of will by the heirs based on mutual agreement. This can be done by the deceased prior to his death, that is again by making or preparing a will. You can call a lawyer, ask for the advice, and based on the advice you ask your lawyer to prepare a will based on your own interest. So in case of the mutual agreement by the heirs, it is done. However, if there is no mutual agreement, there are disagreement among the heirs, this will take legal angle, meaning it will or should be done obtaining or following the legal procedures. The partition of the property is done between the father, mother, husband, wife, son or daughter. So the idea is every or each shareholders of the property will get each of their share on an equal manner. This is called in Nepali GAGAko, means each individual gets their own share. For instance, father, mother, their children, such as the sons, they will have their property divided among themselves, and the married sons, their children or their wives will have the right to claim of the property from their respective husband or the father. So they are entitled to get the property from their husband or from their father. Partition of property among father and mother. In the rural parts, people have misconception that father and mother are not entitled to the share of the property, unlike the son who has reached the majority of age or has gained the legal age. Father and mother, basically, when they put aside property for themselves, known as Juni in Nepali, for their livelihood. So people tend to believe that they only have the right over their Juni. However, that's not true. Father and mother, the parents, have equal right over the property. After the civil code has been passed, in such case, if the parents have already taken their Juni, the part of their share, that will constitute the share of their property. So we have to debunk this misconception that the parents are only entitled to Juni and they are not entitled to the share of the other property. So parents have equal right over the property like sons. The right shareholder of the property dies prior to the partition of the property or during the course of the partition of the property, what happens? In such situation, the right shareholder who doesn't have any heir or has not mentioned the right property holder, unmarried son who has no child or has nobody to inherit the property, or in case the father dies, what happens? In such situation, the share of the property will merge into the original share, from where each shareholder will get the property in an equitable manner, meaning the property that is put aside for these people will be merged into the original property, and everybody gets the same share of the property. In case of the negligence from the husband's side and wife is struggling to live her life, in such situation what she can do? She can claim for the property from the husband, meaning she has every right to claim her share of maintenance or alimony till the time the divorce is completed, or till the time she gets her part of the share of the property. In such situation, she can file a petition or an application before the court seeking or asking for the maintenance cost for the time being, so that she can make her livelihood and sustain life till the time she gets her part of. Not only the wife, but even the children have equal right over the property. Since they are dependent on their parents, they can claim property from their parents and have equal share of the property. Article 214 of the Civil Code clearly mentions or states that daughter-in-law or the wife of the husband can claim property from her in-laws or the husband. Somebody who has already claimed for the share of the property cannot have the right to claim the maintenance cost. In case they have not received their share of the property after filing a case for the property, in such situation they are entitled or they have right to have the maintenance cost or the support money for the time being, which allows them to make a living. However, in a situation where they get their share of the property, that puts an end to have the right to claim over the maintenance or the alimony. So once they get the property of the share, their right to maintenance or the alimony ends there.